And I just want to let the committee know I have another bill being heard in the House at 9:45, so I'll just be hopping off for a minute.
And you can start anytime now, Senator Gray.
All right. Welcome. I am Senator James Gray. Today, we will be having public hearings on House Bill 555, 391, 326, and 292. Before we get started, I will read through the checklist to ensure that the meeting we are holding is in compliance with the right to know law. As chair of the Senate Election Law and Municipal Affairs Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic and in accordance with the governor's emergency order number 12, pursuant to Executive Order 2020-04 and its extensions, this public body is authorized to meet electronically. Please note that there is no physical location to observe and listen contemporaneously to the meeting, which was authorized pursuant to the governor's emergency order. In accordance with the emergency order, I'm confirming that we are providing public access to the meeting by telephone, with additional access possible by video and other electronic means. We are utilizing Zoom webinar for this electronic meeting. All members of the committee and selected legislative staff have the ability to communicate contemporaneously in this meeting through this platform. And the public has access to contemporaneously watch and listen to the meeting on Zoom and YouTube and via phone by following the directions and links provided on the General Court website. We have provided public notice of the necessary information for accessing the meeting in the Senate calendar. We are providing a mechanism for the public to alert the public body during the meeting if there are problems with access. If anyone has a problem, please email remotesenate@leg.state.nh.us or call 603-271-6931. In the event that the public is unable to access the meeting due to problems on our end, we will adjourn and reschedule. Please note that all votes taken during this meeting shall be done by roll call vote. Finally, let us start the meeting by taking a roll call attendance. When each member states their presence, please also state where you are and if anyone else is in the room with you during the meeting, which is required under the right to know law. I will call the roll. Senator Birdsell. You are muted.
Sorry, I'm having some computer issues. Senator Birdsell, and I am in my home in Hampstead in the kitchen/office. My husband is in the house and will be coming through periodically.
Senator Ward.
Ruth Ford, District 8. I'm in my home and started, and I am alone in the room.
Senator Susie.
Good morning. This is Donna Susie. I'm at my home in Manchester and I'm alone.
Senator Perkins Quokka.
Good morning, Senator Rebecca Perkins Quokka, and I am in my home in Portsmouth, and my wife will be in and out of the room.
And I am Senator James Gray. I'm District 6 at my home in Rochester, and I'm alone in this room. Just a little housekeeping before we get started. Senator Susie has provided us an amendment to the bill. I think all of you got that. We will take that up certainly during the executive session. And also our 1FN bill, I was, I guess, forgetting that we needed to exec that today. So I've asked OLS to put a rush on the amendment that I sent you the guidelines for or outline for, and that should be arriving somewhere around 10:30. So you may want to watch your email if you want to review it while we're looking at something else, just in case. Okay, with that taken care of.
Mr. Chair?
Yes, ma'am.
I just wanted to let you know, I think at 10:25, I have a prime bill that will be being heard, and I'll have to hook into that one.
All righty, and I'm hoping to be done by 11 because I've got one at 11.
Mr. Chair, I have one at 10:45.
10:45, all right. That window's getting closer and closer. But I did ask Josh if he was available to take my prime one, but all right. So House Bill 555, and do we have the prime sponsor on the line?
Yes, I will bring in Representative Bolden.
Thank you, Mr. Chairman and members of the committee, for your time and the opportunity to introduce House Bill 555. For the record, my name is Andrew Bolden and I represent Manchester Ward 5. I'd like to start by saying that this bill does not create any rights. If you just read the title of the bill, you might think we're looking to make some major changes here, but I assure you it's much more boring than that. We're not expanding the right to vote with this bill. Current law states that a person behind bars can vote by absentee ballot. The only time an individual's right to vote is lost is when they are actively serving time for a felony conviction, which is addressed in RSAs 654:5 and 607-A:2. So if you're behind bars awaiting trial, or you're behind bars because you were convicted of a misdemeanor and are serving time, you're still legally eligible to vote in New Hampshire. And as I stated previously, this bill doesn't affect that at all. The issue that this bill addresses is that when you actually try to request an absentee ballot, depending on your circumstances, you may not be able to request a ballot or fill out a voter affidavit without perjuring yourself. It doesn't affect everybody, but it does affect a significant portion of the population. I'll use myself as an example. If I got arrested and was incarcerated at Valley Street Jail in Manchester with an election coming up, I would be unable to request an absentee ballot. When you look at the absentee ballot application form, Section 2 lists the reasons you may be entitled to vote by absentee ballot, and you must select one of those reasons. There's an option that states, I plan to be absent on the day of the election from the city, town, or unincorporated place where I am domiciled. That's the most popular option in this form. However, I could not use that option because I'm domiciled in Manchester, which just happens to be where the jail is. And since I'm still in Manchester, I'm certainly not absent from the city. And obviously none of the other options on the form apply to my situation. If, however, I am brave enough to submit false information on that form, and I actually receive a ballot in the mail, it comes with a voter affidavit that I have to fill out. This form is even worse because the affidavit requires me to swear under the penalties of voter fraud that I will be absent from the town or city that I'm domiciled in on election day. Now I have to make a sworn statement, and there's even bold text at the bottom of the affidavit that indicates that providing false information when voting is a Class A misdemeanor with a maximum sentence of a year in jail and a $2,000 fine. And of course, I'm starting to think this whole voting thing isn't really worth the potential to spend yet another year in jail. House Bill 555 would fix all of this. It simply adds a checkbox to the application form and language to the sworn statement in the affidavit for individuals who are incarcerated pre-trial or serving time for a misdemeanor. I did speak with Deputy Secretary of State, David Scanlon, about this bill last year, and he said that they agree this is an issue and they are open to adding this language. This concludes my testimony on House Bill 555. Again, I thank you all for your time, and I'm willing to answer any questions you may have.
Questions from the committee? Then I'll ask a question. One of the last questions on, in fact, on your bill, it's page 2, starting on line 1. I cannot appear at any time during polling hours at my polling place because of employment obligation. For the purposes of this application, the term employment shall include childcare, infirm adults, or with or without. Now, that is the one that I always thought that the person that you're describing would be able to do, although we're stretching the term employment a little bit. Couldn't I modify that just slightly? that would take care of it without the major changes that you're asking for?
Thank you, Senator, for the question. As long as the language on the form made it clear that they were able to vote absentee if they're serving time for a misdemeanor or in pretrial detention, then yes, I would agree that that would be a good compromise.
You mentioned the misdemeanor, etc. We've never had a problem with the misdemeanor that I know of, and if the Secretary of State is on, we may want to ask him a question when we get there. But the felony would also include people who are still on parole for the felony. Is that true?
Thank you, Senator, for the question. My understanding of the law is that the only people prohibited from voting are the ones who are currently incarcerated for a felony. My understanding of the law is that if you're out on parole and kind of still under the observation of a parole officer for a felony conviction, you are able to cast a ballot just like everyone else.
All right. Any additional questions from committee members? Thank you very much. Kirsten.
Okay, the next speaker I have signed up is Patrice Myers. I do not see her on this call, but I do have 2 hands raised already. So if anybody else would like to speak, please raise your hand now. Senator Gray, I do have a hand from David Scanlon. Would you like me to bring him in next?
Let's take a couple of the other ones and see if they have questions that might generate something that we need a response from Deputy Secretary on.
Of course, I'll bring in the next speaker, Henry Clementowicz. Sorry if I mispronounced that.
Henry.
Good morning, members of the Senate Election Law Committee. My name is Henry Clementowicz. I am a lawyer with and lobbyist for the American Civil Liberties Union of New Hampshire. We support HB 555 for many of the same reasons that Representative Bolden testified on. In my view, this is really a housekeeping bill. It has long been the law in New Hampshire that the only people who are disqualified from voting due to criminal charges are people actively serving a felony sentence of incarceration, or people who have been convicted of bribery or other election-related offenses that may lose their right to vote as a result. I think that category of people, the second category, is very small, but the number of people who are incarcerated pretrial or on a misdemeanor is not. And so I view this bill as simply amending the form to conform with what has already been the law. I have no problem with Senator Gray's proposal of trying to find a different way to work in the language into a different checkbox, if that can be done without doing terrible damage to grammar and the English language. I think that's an excellent challenge for some of you. But I think the language proposed by this bill as written is also pretty clear. So that concludes my testimony. Again, we support this bill. I think it's really just streamlining the forms to keep up with the law. And I'm happy to take any questions if there are any.
Questions from the committee? Seeing none, thank you very much. And Kirsten?
So the only other hand I have raised is from Deputy David Scanlon.
Then we will enjoy his company.
Thank you, Mr. Chairman and members of the committee. I'm David Scanlon, Deputy Secretary of State. And I'm in agreement with the testimony that you have heard to this point. The only concern that I would raise is an administrative one, and that is that over the years, we have been expanding the language on the affidavit that appears on the affidavit envelope. And so, the space there is limited. And every time we add language, we are pushing the envelope of making that that envelope readable with a place to sign. And I know the committee has attempted to address the forms, trying to streamline it. I believe Senator Gray has a bill in that would do that. And I would just ask the committee, maybe to take a look at this with that language to see if we can consolidate some of the language on the affidavit form so that it's clear, but is also in a size that is easily readable on the affidavit envelope. And with that, I'd be happy to answer any questions.
Questions from committee members? So, Deputy Secretary, if I hold this one over for a week or two, then we might be able to work on reducing that size of that form some. Is that what I'm hearing?
I would be happy to work with the committee on that.
And one other question, a person convicted of a felony, last I knew that they had to complete their sentence, which would include completing any probationary period or whatever during which they were not confined, but still subject to the courts. Am I incorrect?
Well, in regards to a felon voting, the restriction applies only while they are incarcerated. A felon can be out on parole as long as they're not in prison, they can vote. There is a requirement that precludes them from running for office until their term is complete. Somebody, a voter that's interested in running that is out of prison but still fulfilling the obligations of their sentence would be precluded from running as a candidate until that, until they had completed that sentence.
All right, that could very well be the source of my confusion. Any additional questions? All right, thank you, Deputy Secretary. Anybody else that wants to speak on this? We'll give you a few seconds here to raise your hand.
I'm not seeing any hands raised, Senator.
All right, we'll close the public hearing on House Bill 555. And as soon as you ladies are ready, we will open the public hearing on House Bill 391.
Senator Gray, I'm not seeing the prime sponsor on the line here.
Okay. Let me pull up a copy of the bill so I can see if there's anyone else that's on that bill on the line.
I don't see anybody else on the bill.
Okay.
You want me to introduce it?
If you would, Senator, thank you.
Okay. For the record, my name is Regina Bertzel, State Senator for District 19, the towns of Hampstead, Derry, Hampstead, and Windham. And I'm introducing House Bill 391. 391 increases the dollar threshold for reporting by political committees. Thank you, Mr. Chair.
All right, thank you. And do we have, who do we have on the list?
First, I can bring in Brian Beal from Open Democracy Action.
Mr. Beal.
Good morning, Senator Gray and members of the committee. I am Brian Beal. I'm Deputy Director of Open Democracy Action, which is a nonpartisan pro-voter organization that works on protecting the freedom to vote, fair redistricting, and as we are today, talking about campaign finance reform. I live in Alton Bay, New Hampshire. I'm a constituent of Senator Gray, and I speak to you in opposition of HB 391. When I go to town meeting in Alton and I get recognized to speak on a warrant article, I have to state my full name and my address. This is a tradition that we've had from the beginning of the Republic. Our process has a stand up and be recognized to help our citizens know who is exercising his or her right to free speech and to help us understand the motivation for their testimony. It's a great American tradition that we do this at town meeting, whether we work in the mill or whether we own the mill. We have to have the courage to stand up and be recognized. HB 391 is proposing to raise the threshold for reporting a campaign contribution from $25 to $100. Why? Because it's too much work and costs too much to record the full name and postal address of the contributor, the amount of the contribution, and the date it was received for the public to see who is contributing to the campaigns of their legislators. That seems like a small price to pay for transparency. As we've heard in testimony in recent months, the transparency of our election system has been called into question. We're told that there must be more access for partisan observers, more audits of the election equipment, and more documents included with the absentee ballot. Now, the reporting for a campaign contribution would go up 400%. If HB 391 passes for contributions under $100, we won't know who is donating, what state they're from, their organization, and what special interests they represent. A very conceivable loophole here is that 100 out-of-state union members or corporate employees contributing $99 each to support a candidate who might influence future legislation. $1 here and $1 there, and pretty soon you're talking real dark money. If we really care about election integrity, we should leave the threshold for reported contributions at $25, have them notarized and sent in with a copy of photo ID. The US Supreme Court has said these contributions are free speech, but they also spoke 8-1 for stronger disclosure laws in the states, which New Hampshire has not implemented. This bill takes it the wrong way. New Hampshire voters also have the right to know who is contributing to its legislators in the name of free speech, no matter how large or small their contribution may be. Please support election integrity by making sure we know who campaign contributors are, and vote HB 391 is inexpedient to legislate. Thanks for the opportunity to speak to you today and for your support of New Hampshire voters. I'm happy to take any questions.
Questions from committee members? I do have a few questions.
Sure.
Do you know when this $25 limit was set?
I know it's been in place for quite some time. I don't know off the top of my head how far that goes back.
Would you believe 1997?
Sounds reasonable.
If we index this number for inflation, do you have any idea what that would be?
I don't. It would be an easy thing to figure that out, but I also think that that no matter how small or large the contribution is, the public has a right to know what that is. And I know I get I was a business owner, and I understand what it takes to do accounting. My business had 40,000 transactions a year. I get it. But we're working for the public here, and we need to be able to show the public who is contributing to campaigns.
Do you believe that recording the name, address, and position, employer, etc., has a chilling effect on contributions?
Does that matter? I mean, if it does have a chilling effect on transactions, that would be an interesting thing. If people are afraid and are not willing to stand up and be counted in full view of the public, if they don't feel like making a contribution to a candidate, so be it.
Do you believe that $100 a year is an adequate salary for a legislator?
In my opinion, legislators should receive an adequate salary, but that's not what we're talking about here today.
Do you believe that that it was an adequate salary in 1890, and I forget exactly which year when it was first enacted.
I can believe that. Yes.
Again, the point is, and I'm trying to get you to comment on it, is that at some point, if we have things that inflate in value, that if you're going to have it be relative to what it was at any particular time, then that would have to increase. And from what you're saying is that that $25 may have been worth what $100 was in 1997, but you still don't want to increase it because, you know, when it's worth $1, would we increase it then?
Well, I do believe that this leaves us open to bundling of dark money, where people would organize union members or corporate employees to, it could be hundreds, it could be thousands of people, to flood our system with money that's unaccountable. And you can do that at $100 a time, $100 a contribution. So we run the risk here of opening a Pandora's box of money coming into unaccountable money coming into our system.
Okay, I'm certainly not trying to argue with you, just trying to get out some of the facts out there. Questions from any of the other senators? Senator Ward?
Thank you, Mr. Chair. How would you handle cash contributions?
Well, if in a business setting, you have to take that cash and you would account for that money on your in your income. But in this case, you would have to record the name and position and mailing address and the company that person worked for as a cash contribution.
Follow up?
Yes, ma'am.
Sometimes that is not possible. You find in an envelope maybe a $10 bill or a $20 bill, and there's no way that you know who put that in. And obviously you just add it to the income and put it down, but there's no way you can find out the name or the position or the employer of that particular person.
True. And in this case, if our current threshold is $25, so you would be reporting that as a contribution, but wouldn't have to record for that amount. If you've got $100 bill that is an envelope, and I would hope that our legislators are not receiving envelopes full of cash on a regular basis, but that would have to be accounted for. I don't know that our statute addresses that. Not that I've seen. You have to account for it, but what do you do with one that is over that threshold? I think it should be, either returned to a central pool, perhaps. I mean, certainly a public funding of election would take care of that particular situation, but that's not what we're discussing today.
Okay, thank you.
Just as a what if you got one of those contributions, would it be appropriate to donate it to a charity because you cannot record it in your filings? Any other questions? Well, thank you very much.
Pleasure to be here. Thank you, Senator and committee.
And if you'd like to talk to me more about this issue, certainly you should know my number. If not, I can provide.
Very good, sir. Thank you.
Kirsten.
All right. The only other hand I have raised is Deputy David Scanlon.
Deputy Secretary.
Thank you, Mr. Chairman and members of the committee. I'm David Scanlon, Deputy Secretary of State. And not to take a position on House Bill 391, because ultimately what the limits are in this part of the statute end up being is determined by the legislature. I would like to point out, though, that using $100 is confusing, this part of the statute, because in the first portion, it talks about, any contribution exceeding $100 shall have reported along with that the full name and postal address of the contributor and the amount of the contribution and the date that it was received. And then if you go down to line 12 in the bill, it also says any listing that exceeds an individual's aggregate total of $100 for each election shall be accompanied by the contributor's occupation, including official job title, the name of the contributor's employer, and the city or town of the contributor's principal place of business, if any. So a person under this statute, under this piece of legislation that contributes $100 would have to provide all of that information. And if that is the case, it ought to be mentioned right at the beginning of the statute so that so everybody knows. The other thing that could be done is that you just raise the aggregate amount to something above $100, and that would also take care of what's a kind of confusing conflict here. So I just wanted to raise that point so the committee can address it. Thank you, Mr. Chairman.
All right. Questions from committee members? Seeing none, then Kirsten, do we have anyone else?
I do not see any more hands, Senator. If anyone else would like to speak on the bill at this time, please raise your hand now. And I'm not seeing any hands.
All right, well, we'll close the public hearing on House Bill 391. And as soon as you ladies are ready, we will open the hearing on 326.
And Senator, I don't believe the prime sponsor or anyone else from the bill is on the line either this time.
All right, let me open that bill.
Kirsten, which bill are we talking about?
HB 326.
Do you want me to, if there's no one
If
here?
you would, Senator.
All right, let me just call it up. Okay, again, my name is Regina Birdsell, State Senator for the towns of Derry, Hampstead, and Windham, and introducing House Bill 326. This bill requires that town and city clerks make electronic lists of persons who have requested, been mailed, or returned absentee ballots available to candidates upon request. Thank you, Mr. Chair.
All right. Do we have anyone? Kirsten.
I have no one signed up to speak, so if anyone would like to speak on the bill at this time, please raise your hand now. And I'm not seeing any hands, Senator.
Is the Deputy Secretary there?
Yes, he is.
Deputy Secretary, any comments from your office?
The only comment I would make, Mr. Chairman, is that I'm reading the text of the bill, and what the text does is it would require the clerks to provide an electronic copy of a list of absentee voter applicants. And I'm looking at the title of the bill, which says requiring town and city clerks to make electronic lists of persons who have requested, been mailed, or returned absentee ballots available to candidates upon request. I think that if that's what is intended, provide that information, that it's not clear to me just reading the bill that the bill accomplishes that. I was trying to read the rest of the statute quickly to see if that information is applied elsewhere in that statute. But it's not jumping out at me at the moment. So I will look into that and let the committee know if what I just conveyed to you is different than, what's in the statute.
Senator Bertzel.
Thank you. David, I'm just curious, are the town clerks already doing that, or are the clerks already doing this or something similar to this?
Right now, the clerks are required to keep a list of those voters that have requested an absentee ballot. And in some cases, it's on a spreadsheet. It's a manual list. I don't believe the list is generated by ElectionNet, which is the voter registration database. And candidates are permitted to acquire that list of the absentee voters that have requested a ballot. I think the information that they provide is somewhat limited, and I don't think it extends to the point that is mentioned in the title of this bill. In other words, I don't think that the information they provide would include when an absentee ballot is returned to the clerk.
Okay.
And so, if the intent here is for the clerk to generate a list of the absentee voters from ElectionNet, with this additional information on it, that would have to be spelled out in the statute. And again, I am not sure that the language that is in the bill even does that. But I'll look into that further just to confirm that.
Follow up?
Yes, ma'am.
Does ElectionNet have this information in it, or would it have to be entered into it?
When the clerks receive an application for an absentee ballot, mail out the absentee ballot, receive the absentee ballot back, that information is recorded in ElectionNet. In fact, the voters have access, absentee voters have access to that information if they get onto the Secretary of State website and plug in their personal information. They can pull up the status of their absentee ballot. So that information is in the database, and because it's in the database, it could be generated as a report.
Oh, okay, follow up.
Yes, ma'am.
So if then all of this information is in ElectionNet, the persons who have been requested, been mailed, and returned to absentee ballots, that's all in ElectionNet?
That is all in ElectionNet, provided the clerks have entered the data, which they are supposed to do. Yeah.
Okay, so last follow-up, I promise.
Feel free, Senator.
So it would just be a matter of, if all the information is, if the clerks have already put everything in there, then it's just a matter of running that report. And it also says the clerk shall not require prepayment prior to releasing, excuse me, such lists. So is that correct? Information is already in there, and it would just be a matter, if it's already in there, just a matter of sorting and sending it and getting it to them. Is that correct?
The clerks should be able to generate a list from ElectionNet. I think part of the process now is because they maintain a list outside of the database, whatever format they choose to, they do or can charge a per page copy for those lists, which I think most of them do if somebody comes in requesting that list.
Right.
And that would be at the normal per copy rate that the town normally charges.
Okay, thank you.
Additional questions, Senator Susie.
Thank you. Deputy Scanlon, and I just tried to pull up the statute and was glancing at it quickly, but would the current law apply to municipal or local elections? Is that, I know the prime sponsor isn't here, so I wasn't able to ask. Is that what they're trying to get at?
I'm pausing because I'm taking a look at the bill to see if it is. Yeah, this is in the state election part of the statute. So candidates, I should say, yeah, I mean, candidates have the choice of going Well, when they're requesting information about absentee ballots, they have to go to each individual city or town clerk in their district to obtain those lists. The only list that the Secretary of State is authorized to provide is a statewide subscription to candidates who are running for a statewide office. So we can't break it down any smaller than that, although you know, there is legislation that is pending this session that would allow parties to obtain that list as well.
Thank you.
Additional questions? All right, thank you, Deputy Secretary. Kirsten, anyone else?
I'm not seeing any hands, Senator.
All right, we'll close the public hearing on that bill, and we have a couple of minutes. It looks like, since we're going right along, 292 may take a little longer, but we have 3 of you which are going out for prime bills. So instead of trying to go into executive session now, I think I'm going to hold that off. So we will suspend until quarter of, take that bill. And then we probably also will recess for a short time because I don't believe the other bill has come through. So just for your planning. And okay, so we'll be back at quarter of. I now have quarter of, so when you ladies are ready, I am ready.
All right, and we do have the prime sponsor here,
All right.
Representative Hill.
Good morning.
Good morning.
Just you, Senator?
The others are here. We had a couple of minutes, you know. And
Yeah, I do. I understand fully. Well, let me begin by saying I am Representative Greg Hill. I cover Merrimack 3, which is the town of Northfield and 1/3 of the city of Franklin, New Hampshire. I'm here to introduce House Bill 292 to you, which deals with a specific subset of absentee ballots. I should point out, first of all, that there is an amendment that Senator French completed for me and should have been sent to you. It is Amendment 1338S. Uh-oh.
Oh,
I'm
sorry.
seeing puzzle looks there, but at any rate, that just corrects one small sentence in the bill. I will start to tell you that this is a bill that is interested in clear and verifiable evidence that the person that is voting is precisely who he or she says they are. This is also a bill that may be familiar because it is a bill that was heard last year as Senate Bill 489. And although the bill failed, I think a similar bill was also filed in the Senate this year. Last year on the Senate floor, Senator Morgan spoke and said that this bill was not needed because there had been, quote, no indication showing the situation is widespread. I would like to point out to the senator that evidence of a widespread problem is not required to fix this type of problem. I've been dealing personally in financial services for 40 years. At one time in that industry, a participant in a 401k anywhere in the country could name anyone they wanted as beneficiary of their account. However, after 4 spouses of members in a public pension in Massachusetts were told that their husbands had named their girlfriends as beneficiary of their pension instead of their spouse, the law was changed. And now, if you want to name someone other than your spouse as beneficiary, the participant must have their spouse sign off and have that signature notarized. Again, this is an additional requirement that happened just as a result of 4 spouses. Coincidentally, this House Bill 292 also deals with notarization as a solution. It also pointed out that this potential problem deals with specific and a small subset of voters. These are voters who A, request an absentee ballot by mail, and B, request that their physical ballot be mailed to an address not shown on the voter checklist. The problem to be solved is that it appears very easy for a person wanting to steal votes to acquire these votes by locating a large number of people not voting in a given election and simply claim to be that person on a ballot request form. No proof of identity is currently needed. Clerks are unable to detect any fraudulent activity when the request comes by mail without proof of identity. It seems amazing to me that anyone would vote against this type of legislation. Can anyone imagine if we allowed a bank to simply operate the way we allow our clerks? Imagine if a bank simply received a letter saying, I am Senator Morgan. Please close out my bank account and send my money to this address in Akron, Ohio, and having that bank comply. But that is exactly what we allow to happen with a ballot. The solution proposed in this legislation is to require the common solutions to similar situations, either a copy of your ID or notarized signature along with your application, the same things that the bank would require, the same things the 401k company requires just to name a beneficiary. I believe we should require it as well. Voting should be done with clear and verifiable evidence that the person voting is precisely who he or she says they are. And with that, I'm happy to answer any questions.
Questions from the committee members? Trish, before we dispose of him, would you put up the amendment that he was talking about on the screen, since apparently we do have it?
I do not have it yet. I've requested it.
Oh, okay.
I didn't.
I can describe it. It's a simple problem that the OLS attorney, when she misunderstood my direction, it says in there, and I'm not sure the line, it says that the absentee person requesting the absentee ballot would provide to the clerk a copy of their ID. And it was pointed out that they wouldn't be able to show that ID if they were requesting by mail. So this amendment simply asks them to provide a copy to the clerk, not the actual showing of the ID to the clerk.
It's in line 8.
Okay.
It says the voter voluntary shows the clerk a photo.
Right.
Okay.
And this would provide a copy instead of shows.
Representative, did you review Senate Bill 54 and how we attack this issue in that bill?
I have to beg some ignorance here. I do know that the bill exists. I did not examine it, I'm afraid. I was hoping when that has a hearing to take a few minutes before and take a look.
If you would take a look, we've got at least 3 people on the list, I think, that are going to testify. And Senate Bill 54 changes the application form and asks for either the driver's license number and state, last 4 digits of the social security number, or some other information that's verifiable by the clerk. And I would just like to get your comment on that if you do have time to review it before we end the hearing.
Certainly, I will take your description of the bill and tell you right now that I would be thrilled with any level of identification being required. It sounds from what you described to be something that I could have written myself. I didn't think of the last 4 digits of the social, or I may have included it in this. It is, it just seems vital to me that we have some manner of identification for someone who requests by mail, and the clerk has no positive way of knowing that that is the person who says they are.
Okay, questions from any of the other committee members? Why I ask Representative Hill to go off and do a little reading before we get someone back in the hearing.
Wait, do you have a hearing date yet? As yet, Mr. Chairman?
Right now, I was hoping if you could stay on the line. We have, like I say, about 3 people that are signed up to testify, and I just it sounds like we can come to an agreement with you.
It does.
But we should at least let you read that. And so I'm going to put you on hold right now and have Kirsten call up one of the other people who signed up.
And I will send you, Representative, I will send you SB 54 to your email.
Thank you very much.
All right, so we'll return to Representative Hill later. I will bring in Olivia Zink.
Ms. Zink.
Good morning, Senator Gray and members of Election Law Committee. For the record, my name is Olivia Zink. I'm the Executive Director of Open Democracy Action, and I live in Franklin. We're a nonpartisan organization, pro-voter organization, whose mission is really around strengthening our democracy. And I really want to thank this committee for all of your hard work in creating a fair process for voting. COVID-19 has created some stress on our democracy. And it's really important that we ensure that our election systems are working. I am here to speak in opposition to House Bill 292. This bill requires a ballot to be either a photo ID to be shown at town or city hall, or for a signature to be notarized. The third provision of this bill, the signature match, has been struck down by the court. I think it's really important that we understand that in order to get an absentee ballot, you are most of the time already a registered voter. I do understand that you can register to vote by mail, but that does require you to provide supplemental documentation to prove when you're registering. I do want to, if a voter is in a nursing home, they can vote from their former address. So this bill would address would impact voters who are voting in a nursing home, and some of them may not physically be able to get a photocopy, or go in person to show their photo ID, or might have mobility issues in order to have their form notarized. So I think it's really important that we look at this. According to the National Notary Association, it does cost about $10 to get some form notarized in New Hampshire. It is something that a bank or a lawyer can do for you, but I do think that that does put a burden on disabled voters who may not be able to get notary services, or somebody who is out of state working on a work errand. This requires them extra time. It also, these restrictions do provide additional work for our city and town clerks. And we already have an absentee ballot system that works. This bill requires extra money and time and resources in the clerk's office that I do hope you provide if you do pass this. I do want to speak to the signature match part of this bill, because a federal judge did strike down this language stating that it disenfranchises hundreds of voters in New Hampshire. U.S. District Judge called this fundamentally flawed under the Equal Protection Clause of the 14th Amendment of our Constitution. So I would urge you to look at that. I do want to speak to something that the judge did cite is they cited about 2 voters from the Laconia Rehabilitation Center who were disenfranchised under the signature match law in 2006. This was in the Senate District 7 race, which covers Franklin and Laconia, and this was decided by 17 votes. And so when you have 2 voters that are being disenfranchised in a Senate election that was very close, I think it's really important that we look at these bills. And I do think that this committee has already worked on amending Senate Bill 54. The House has heard this. Last week, the House election law had a work session on 54. I have not seen the House version of an amendment to 54, but that is coming. So I think because you've already done the work on Senate Bill 54, I urge you to either ITL or re-refer this bill. And with that, I'm happy to take questions.
Questions from committee members? I do have a question. As I read the ruling from the court, that they said that the signature match, because it had no way to cure and that the people weren't trained, those were the 2 things that would have to be fixed in order to reinstitute the signature match. Am I incorrect in that?
That is my belief of the court ruling, that you do have an ability to cure. And with pre-processing this year, we did provide some opportunity for absentee ballots to be cured, but I think that still has not been fully solved in our election system, and those have not been permanent changes. So before the 3rd part of this bill around the signature match is enacted, I think those need to be addressed.
Thank you. Additional questions from committee members? Seeing none. Kirsten.
And our next speaker is Todd Fahey.
Good morning, Todd.
Good morning, Mr. Chairman. Thank you for having me. Good morning, members of the committee. I am Todd Fahey, the State Director of AARP New Hampshire. We appear today in opposition to this bill, and we've submitted written testimony as well. I sent it to Ms. Malillo, and she nods that she has it. You can't see me, I suppose. Did you want to? It's often a benefit when you can't, but
we're fine the way it is.
Yes.
Okay, that's fine. So here's where AARP is an organization committed to voting and civic engagement in all of its many variations. That's what we do. We are a nonpartisan organization. We have some 215,000 members in New Hampshire. The numbers go up and down given a size of people that large, but presently it's around 215,000. And we're really pleased to say that most of our members vote with regularity, as does the 50 plus, the most reliable voting bloc in America. And, I'm certainly a member of that and work for an organization that does as well. I will also remind the committee, if you don't know, that I am a resident and a native of the fine state of New Hampshire. I not only have the privilege of running AARP in the state, but I'm a voter here and I've been very engaged with civic things for years. So we are nonpartisan. This has nothing to do with partisanship.
Todd, if you could get to the comments on the bill, I'd appreciate it.
I'll be happy to do that, Mr. Chairman. The comments are as follows. Voting is a fundamental right. Disenfranchising one voter is a violation of the rights that we hold dear as people in New Hampshire. Because this has a mechanism, this bill has a mechanism for perhaps inadvertent disenfranchisement, we oppose it. So again, examples of this is as follows. A person leaves their home and may move to an assisted living facility. I can tell you without getting into details, I was involved in this very situation personally in the state within the last election cycle. Person leaves a home, goes to an assisted living facility, and there's a disconnect between the address on the official roll. Once that happens, then the requirements of this bill would come into place, and they are at least two: a photo identification or the requirement of a notarization. That's a problem for people for reasons I've set forth in my written testimony, because many people don't have photo IDs. In my particular situation, the person for whom I'm responsible, frankly, no longer has a valid driver's license. So, then the question becomes, is there a valid form of photo identification? Beyond that, and I think the prior Ms. Zink spoke to this, getting a notarized signature isn't quite so easy. I mean, it's fine if you're able to find somebody to notarize, be it a bank with whom you have a relationship, to be clear. You can't just always go into any bank, or a lawyer if you have a relationship. But it isn't always so easy, and certainly more difficult if you can't get to a notary. So for these reasons and other reasons we talked about in my written testimony, we object to this bill. I think we had a relatively safe, wonderful elections in 2020. This from the Secretary of State's office. We had some hiccups for sure. There were some challenges. I understand that. But generally speaking, the process that we have in New Hampshire and that we're all proud of worked well. There is no reason for this additional legislation. For that reason, I would ask the committee to decline to pass it out of committee. Thank you, Mr. Chairman.
Questions? And Mr. Fahey, are you familiar with Senate Bill 54?
I am. I testified in opposition to that in the House, Mr. Chairman.
Okay. Any other questions? Okay, thank you very much. Kirsten.
Thank you, Mr. Chairman, committee members.
The next speaker is Bob Perry.
And senators, I just sent you the amendment from Senator French on this bill
Thank you.
that Representative Hill was discussing.
Representative Perry.
Good morning, members of the Senate and Mr. Chairman. Thank you for the smile. I speak in opposition to HB 292. My presentation will focus on references to signature matching. And by the way, I have a tie on, so you can show me if you'd like. I'm prepared.
We'll believe you.
Aside from the natural evolution of a person's handwriting with age, and specifically the changes in a person's signature with age, I have come to understand the numerous other valid reasons that signature comparison is problematic. The National Multiple Sclerosis Society reported 2 years ago that, quote, around 900,000 Americans, and quite possibly more than that, have multiple sclerosis, easily double the long accepted figure of 400,000, end quote. Women make up 74% of known MS patients. Linked to a vitamin D deficiency, the farther away from the equator, the higher the incidence of the disease. People living in the 9 US states comprising the Northeast, of course, including New Hampshire, quote, have a high prevalence of 377 cases per 100,000 inhabitants, end quote. Thus, there could be as many as 4,524 New Hampshire inhabitants, among them voters, whose handwriting could be affected day to day based on severity of the disease, medication levels, and other variables. Quote, MS includes loss of hand dexterity and finger movement control. This affects a patient's capacity to manipulate objects and coordinate hand movement, skills needed in handwriting, end quote. I searched for the phrase diseases that affect handwriting. Results, Huntington's disease, as many as 200,000 in the United States. Parkinson's disease, an estimated 3,600 in New Hampshire. A condition known as dysgraphia. The onset of Alzheimer's, an estimated 26,000 cases, ages 65 to 85 plus in New Hampshire. Multiple handwriting styles in one person, and schizophrenia. Even professional handwriting experts disagree in analyzing the same signature as in a court setting. Indeed, judges in both criminal and civil cases instruct the jury that they may choose to accept the testimony of one expert over the other, or choose to accept the testimony of neither. Lastly, I note that in August of 2018, federal judge Landia McCafferty struck down a 40-year-old New Hampshire signature match requirement that had disenfranchised more than 800 voters in prior elections. The court concluded the law to be fundamentally flawed and unconstitutional in part because the voter was not provided notice that his or her vote was rejected, thus denying the voter the opportunity to cure the defect. The court cited the Equal Protection Clause of the 14th Amendment to the US Constitution. The judge also noted, quote, it cannot be emphasized enough that the consequence of a moderator's decision, disenfranchisement, is irremediable, end quote. In that regard, I suggest that disenfranchisement by act of a moderator is legally actionable. And the judge in that case made that same reference. For the reasons noted above, the folly of signature matching in general, and the federal court ruling, I urge ITL. And I thank members.
All right, Representative Perry, are there questions from committee members? All right, thank you very much.
Thank you, sir.
Kirsten?
And the last speaker I have signed up is Christy West.
All right, if Christy West is the last one, we'll go to Representative Hill, and if anybody else wants to speak on this bill, I suggest you raise your hand now because we'll be closing the public hearing.
Did you unmute me?
Yes.
Can you hear me? Okay, fine. Sorry. I thought you were skipping right over to the representatives. I apologize.
Nope.
My name is Christy West. I'm a resident of Mount Vernon. I travel frequently for work, and I actually, during the pandemic, I've been in North Carolina taking care of my mother. Olivia's point about elderly people in nursing homes and the second speaker, I can totally agree with, because my mother is 94 and I know what my abilities are now. I could go get a notarized statement. I have a photo ID. She does not. So she's a North Carolina resident, but I'm just looking at it from the point of view of Parkinson's friends that I have in nursing homes in New Hampshire. They would not be able to live up to this requirement, and it's just an extra burden. I feel like I know our town clerk knows me personally. They have such a good grasp on who the voters are. I cannot believe the sponsor of the bill, I apologize, I forgot his name, that he said that someone would go collect voters who voted absentee and somehow send in multiple letters and vote in their stead. I can't even fathom that happening, how they would actually make that happen. But also just, there are lots of other ways, I guess, that there could be fraud, but I don't think that would be it. And if that's there is not a problem. And I'm not sure that this bill would do anything to provide a solution. You guys have mentioned Bill 54. I'm not familiar with it. I strongly oppose the signature requirement because of what the just prior speaker spoke of. My son has MS. My friend has Parkinson's. My mother is 94. Her signature is nothing of what it was when she originally registered. It is not a valid form of identification. So I strongly oppose this bill. I respectfully ask you to consider that opinion as a person who's experiencing it right now.
Questions of committee members? All right. Thank you, Ms. West.
Sure.
Representative Hill, did you have any final comments?
There we go. The only comments I had a few minutes while I was listening with one ear to those testifying against the bill, to also read Senate Bill 54, and it would seem to tick all of the boxes for me. I did like seeing other in there, and I maintain that it may be another possibility in that other category to allow an absentee voter to get a notarized signature. Again, that should be differentiated from signature match, because you're actually in front of a notary, and they're just indicating that you are who you say you are, which is the key point for this legislation. That's all we hope to have happen with this legislation, is that the person that says they are John Jones is John Jones, and we have verification that that's the case. So I'm happy to. I don't know what the amendments are that they're talking about that are being Senate Bill 54 amended. I will take a look for that today.
All right. Questions? Seeing none. Thank you, Representative.
Thank you. Have a great day, everyone.
Any other hands go up? Kirsten?
Yes, Senator, we have one hand. I will bring them in. They're under the username MK, so if they could please identify themselves for the record.
Hello, my name is MK Kilcoyne. I'm going to be very brief with this. We heard a lot of people speak about having to take care of loved ones and how this affects the elderly. I am currently 29 years old, but I am a 6-year cancer survivor. At one point in time, I had to be in the hospital for over a month to get a stem cell transplant that essentially brought my immune system back to zero, and I physically could not leave the hospital. I just want to give you another perspective of I would have loved to vote at that time and no way could comply to what was on this bill. So that's all I have to say. Thank you.
Okay, MK. Questions from senators? Seeing none, thank you. One last time, Kirsten?
We do have a hand from the Deputy Secretary.
Deputy Secretary Scanlon.
Thank you, Mr. Chairman and members of the committee. Once again, I'm David Scanlon, Deputy Secretary of State. We're not taking a position on this bill, but I did want to comment after listening to the testimony and say that this bill does not appear to change the current statutory process for absentee voting. Whether a person is in a nursing home or whether they're having their ballot sent to another location, what this bill appears to do is create a process to automatically have the absentee ballot verified so that it will be counted on the day of the election by providing this additional information. But I don't see anything in this bill that changes the existing statutory process. And with that, I'd be happy to answer any questions.
Questions from committee members? All right. Thank you, Deputy Secretary. One last time for you, Kirsten.
If anyone else would like to speak on the bill, please raise your hand now.
With that, we'll close the public hearing. All right, let me just figure out what's happening with all of you. Senator Perkins Quokka is out of the prime bill now. Senator Ward, was it 10:15 that you needed to go?
10:45.
10:45. And Senator Birdsell, you are
10:25.
10:25. All right, and I think I found somebody to cover for me for 11.
I'm not going anywhere, Mr. Chairman.
You're not going anywhere. All right, well, it appears that we do have a couple of minutes before, but Senator Perkins Quokka is in here. But at least we could bring your amendment up on the screen. Senator Susie, if we do go into executive session for a little bit.
Sure. Move we
do
go
I have
into
a motion?
executive session.
Let me silence that. So do I have a motion in a second? I was distracted. Okay. I'll call the roll. Senator Birdsell,
Yes.
Senator Ward,
Yes.
Senator Perkins Quokka is excused, and Senator Susie.
Yes.
And the chair votes yes. We're in executive session. And we bring up Senator Susie's amendment.
Yes. Sorry, hang on. Make sure I get the right screen here. And I will make it bigger.
Oh, I sent you I actually have the OLS copy.
Oh, okay.
I apologize for that, Trish. That was my error, but I can still describe if I'll
Okay.
have it in by the time we cast the ballot. But if you scroll up just a bit,
Let me just make
all
it
that, yeah, all that's added is the language that's underlined. So in the section about candidates and in the section about political parties, adding the date the ballot was returned as a field that's already there. And then in Roman 4, adding that the Secretary of State provide the list requested at least once a week or at least twice a week, 4 weeks prior to the election, which is basically what is already being done and can happen more frequently should the Secretary deem appropriate.
Okay. Questions of Senator Susie? I can't see any hands, so.
You want me to stop sharing it?
Oh, well, can either of you two ladies see the hands? If Senator Birdsell or Senator Ward want to speak, I'll just speak up if you want to.
I'm sorry, say that again, because I had it way down.
Just if you wanted to ask Senator Susie any questions about her.
I'm good. I read it this morning.
All right. All right. Well,
And I did just get the amendment for 523, so I will send it along and then I will share it if you want.
well, I'll just bring that one up.
Okay.
I haven't seen it yet, and I didn't try to write the words myself. I tried to let them write them.
Okay.
On 523, it seemed like the discussion was going along that we only wanted one photograph to be taken. The record that would be kept the longest is the one at registration. And so what I asked him to do is to modify the statute that has them taking the photograph at the, when the voter checks in, to say that if the photograph has already been taken, then there would be a note put on the document, the challenged voter affidavit, I believe it is, saying that the photo was taken at the other table. So I think we need to scroll down a little bit.
I think that's right there. Can you see that or no?
I can see it, but I think we need to see past line 16. So
This is all I have for the amendment.
No, we can't see the bottom half of the page. We can only see the top half of the page.
Oh, okay. I don't know why.
Because you have to scroll.
I am. Yeah, I'm scrolling on my screen and it's not, okay.
Oh.
Yeah, it looks like it's all the way down.
okay, but the portion that you can see at line 14, however, if a photograph was taken under RSA 654.12, then a notation shall be made on the challenged voter affidavit stating that the photograph is attached to the qualified voter affidavit, or, and I can't read anymore, so. Unshare it and then fix it on your screen and then share it again. How's that?
Yeah, maybe that will, okay, hold on. So it's not moving on to you guys, it's not moving at all when I'm
Okay.
scrolling? Okay. Let's see. All right, let me try this again. Okay, now. Can you see it now?
Yes, Ken.
Okay.
And so it was just that extra little part of that sentence on 17 would be the modification to the bill that would allow only one photograph to be taken. Since we're not all together, committee members, what do you think about getting back together at 11:30? That should give you all time to do that. It's still within the time that we should have carved out for this committee. Trish, you can contact Senator Perkins Quokka and tell her 11:30, and then we'll try to go through as many of the bills as we've got at that time. So with that, I don't know that we need to go out of executive session if we suspend, but
I think we can just, you can just recess it to 11:30, I'm pretty sure, and we can just put a sign up that says we're in recess.
Right. Yeah, that's what the House does.
all right. So with that, we will be back with you at 11:30.
Do we need to go? Do we need to vote to go out?
I don't think, because we're going to be in executive session.
Okay. Go
And
right back
this-
into exec.
The
Mhm.
statement can say in executive session, but recessed until 11:30.
Okay.
Okay.
All right. We'll see you all at 11:30 then.
Okay, thank you.
Bye now.
Trish, I'm going to send you the updated or the actual OLS copy right now.
Okay.
Apologize for that. I thought I had done that.
That's okay, thank you.
Oh, no, they're in recess until 11:30. Election.
Senator
law member-
Perkins Cuoca.
Yeah,
This is Jim Gray. Because of all the people who have got various bills, it didn't look like we were going to be able to have all the members present until 11:30.
okay.
So
Understood. I was hoping to be done by 11:30, but we did make it very challenging this morning, so no problem.
okay, you should
okay.
have, you should have a copy of Senator Susie's amendment, and that's on House Bill 98. And by then, you should also have a copy of the amendment on 523, and we'll go from there.
All righty. Thank you so much, sir.
Bye now.
Bye-bye.
I now have 11:30. I do know that Senator Perkins Quokka came back and looked for us shortly after we recessed, and I told her that we were getting back together at 11:30. She did say that she was hoping to be done by 11:30, but didn't say she wouldn't be back. And I see Senator Ward is still have 11:30.
Oh, sorry. There we go.
Okay.
I can reach out to.
Mr. Chairman, it's my understanding the only bill we have to act on today is House Bill 529 because it's our last FN. Is that correct?
523, I think.
523, I'm sorry. Yes.
Yeah.
Okay.
I would like to do a few more just to get them off our plate, but if
we just need a couple more members.
we've got such a good record of putting things on consent because we all reached consensus that I would hate not to do that. So Senator Ward, are you still there, or? I know she's muted.
Senator Susie, we were supposed to work on a bill, weren't we, together?
Yes, but I didn't want to disturb you last week, so I'm happy to talk to you later today. It was the bill about rescheduling the date of the primary, I think.
Yeah.
And while we're waiting for Senator Ward, we'll just open that one up for comment. You know, there are those that have approached me and said, yeah, gee, we really got to do this. And those that say, no, that would be the worst thing. I know the Secretary of State isn't all in favor of that. Myself, the compromise would be to move to the third or fourth Tuesday, depending upon when Labor Day falls. You know, and that's kind of hard to describe, especially when there can be 5 Tuesdays in that month. And that's why I mentioned the 4th, because if there's 5 Tuesdays in there, I would like to stay at the 4th. But if there is only 4, probably would want to go back to 3. Comments from other senators, what you think about removing the primary?
I think it's a good idea. It's something that I've supported for a while. I mean, I'm, certainly open to the June date. I do understand the concern, though, and it's something I want to discuss more offline. The fact that it's a redistricting year, so people are going to have to file so much earlier, perhaps even before they know districts. That part of it is complicated, and I know that sponsors tried to address it by having the Secretary of State make that declaration. But I think if we're going to set it, we should just affirmatively set it. And, maybe it's not until the 23-24 term, but.
Yeah, the only concern, not the only concern, but one of my major concerns is, and I know they say that the current system is an incumbent protection plan, but by moving it to June, the senators are going to be at a complete disadvantage because our filing period is going to be the March-April timeframe. And guess when we get all of our House bills, and we're super busy. So we're more inclined to have to be working much more than, let's say, the state reps are during that period where we won't have the time to do the campaigning that we probably should. So, so I do have a problem with the June timeframe. I would prefer August, but and again, I hear the concerns about that is it's like the middle of, the summer, people are away. So I'm not sure that there's a good answer anywhere.
I know the state of Vermont changed theirs and they went to, I believe, an August date. They actually had an increase in voter participation.
Oh, we should look into that.
Yeah.
Okay.
All right. If Senator Susie and Senator Birdsell will continue to work on that. I would appreciate it. If any of the other senators want to comment while we're in executive session, that would be appropriate. Seeing none, we'll move on to House Bill 523. And that is the taking of the picture. There will be those that say, hey, we take a picture, that's good enough. The thing that intrigued me about this when I looked into it is the difference in how long you keep that information. If we do it the way we are now, the picture is only retained for the period of time the ballots are retained, really. And that's what prompted me to write my amendment the way I did.
So does this mean they only have to take one picture since they're already taking a picture? It's just noted so that if they want to check it, they can?
Right. And it would be attached to the document that is retained the longest, which is the affidavit that they would sign during registration. And the one that they would have signed during voting, since that, again, is only kept, I think it's 22 months after the election. So that's what the amendment does, is it goes into that statute that takes the picture during voting and just puts the exception in there that if they registered that day and the picture was already taken. Questions on that bill?
Yes, if I may, Mr. Chairman.
Yes, ma'am.
I definitely appreciate the work on the amendment to eliminate the redundancy. But how much longer is this photograph going to be retained if it's taken and attached to that document instead?
7 years after the voter is removed from the list.
7 years after the voters?
That's what the registration, all the registration information that they provide, according to the retention statute, is kept for 7 years after the voter is removed from the list.
So it's consistent with current law.
Yep.
Okay.
All right. Do we have a motion on House Bill 523?
I move on to pass.
We have an ought to pass motion.
Second.
Seconded by Senator Ward. I will present amendment 2021-1360S. Do I have a second on that amendment?
Second.
Seconded by Senator Birdsell. Discussion on the amendment. I will call the roll. Senator Birdsell.
Yes.
Senator Ward.
Yes.
Senator Susie.
No.
Senator Perkins-Coca.
No.
And the chair votes yes. The bill now is, the motion is ought to pass as amended. Do I have any discussion?
I would just say, Mr. Chairman, once again, I always appreciate your thoughtfulness in trying to reach compromise and work through these issues. But I think the period of time that this photograph will now have to be retained, it will probably be faded by the time it's removed from the record. So I don't know that the legislation is really necessary. But as I said, I do appreciate your thoughtfulness in trying to work through some of these issues.
Yep. And I echo comments of Senator Susie. I appreciate the thoughtfulness. I just think that our current procedure works fine. So.
Okay. No other comments. I will call the roll. Ought to pass as amended. Senator Birdsell.
Yes.
Senator Ward.
Yes.
Senator Susie.
No.
Senator Perkins-Coca.
No.
And the chair votes yes. And I will take it up. Okay. If we could take up House Bill 223.
Ow. Move ought to pass.
Okay, we have a motion of ought to pass on the bill,
I'll second it.
and we have a second. And Senator Sister, you want to present your amendment?
Yes, if I may. Actually, let me just pull it up again for myself.
1347S.
Yes, so 1347S amends the bill in two ways. The sponsor's original intent was to expand the statewide access to parties, which I think is a great idea. I just added two provisions, one that would add one additional field, which is the date the ballot is returned, to both the current language for candidates and then that new language for parties. And then at the end added a provision that the secretary share that list at least once a week for the subscribers and at least twice a week in the 4 weeks leading up to the election. And obviously it's an at least, so should the secretary deem it appropriate to do it more frequently, that's within his discretion. And I would move the amendment.
Okay,
Do you need a second?
Yes.
all right. Do we have any discussion on the amendment? Seeing none, I will call the roll on the amendment. Senator Bertzel,
Yes.
Senator Ward,
Yes,
Senator Susie,
Yes.
Senator Perkins Quokka,
Yes.
and the chair votes yes. And now we have ought to pass as amended. Do we have any discussion? I'll call the roll. Senator Bertzel,
Yes.
Senator Ward,
yes,
Senator Susie,
Yes.
Senator Perkins Quokka.
Yes.
Do I have a motion for consent?
So moved.
second,
Okay, I'll call the roll. Senator Bertzel,
Yes.
Senator Ward,
yes,
Senator Susie,
Yes.
Senator Perkins Quokka,
Yes.
and the chair votes yes. Yes, Senator Susie.
Yes, I'd be glad to take it out.
I'm sorry, who moved consent?
I did.
Thank you.
Trying to move along, be efficient.
Yes.
All right. House Bill 484. I want to open that one up for discussion. Mr. Johnson and myself have not been able to come to any better words than what's in the bill now. The bill, personally, I believe that if the Budget Committee puts things on there that are beyond the scope of their authority, in other words, comments on things that are not, don't have an appropriation or expenditure, that could constitute electioneering by, putting that information out there. So not being able to find out anything more than, the words that are on this and not being able to come up with better, I'm kind of left with these words. Comments from the rest of you?
I just thought it was unnecessary. It seemed to me that particular day when we were hearing this series of bills that it was a group of people who had a particular issue in a particular town and that this was not sort of a widespread problem. I just don't see the need for the legislation.
Other comments?
I don't know. I have a tendency to agree with Senator Susie, but what is the thoughts on the rest of the committee?
I don't feel strongly. There's some some logic to the legislation, but I certainly could vote with Senators Susie and Birdseye unless this is a widespread problem, which we really didn't hear about.
Well, this is, I think this is more belts and suspenders than anything else, but because it doesn't sound like they're authorized to do that anyway.
Right.
Senator Ward, you're the only one that hasn't talked to the bill.
Yeah, I'm looking at it, sometimes we get into the weeds on some of these things. I'm just wondering how I'm looking at the hearing report who was for this thing. There's a couple. And then we have Norman Silber, and then the others who said it's absolutely useless. And I had a note here that Cordell and Diana Howard was supposed to get together and do something, and I take it that they haven't done that. I haven't heard anything more from her. So I don't know. How about ITL?
I worked with, and I'll accept the motion to ITL and we'll get a second,
I'll
but
second.
I will comment on that. I did try to work with Cordell Johnson on this. And again, the problem is the way the statute is written right now and trying to fit it in where it will be recognizable and, and actually describing what they do and what they can't do. So with that, we have a motion of ITL. Is there any other discussion? Seeing none, I will call the roll. Senator Birdsall,
Yes.
Senator Ward,
Yes.
Senator Susie,
Yes.
Senator Perkins Coca,
Yes.
and the chair votes yes. And we've got a motion to consent, I would guess.
So move. Second.
We have motion moved and seconded for consent. I'll call the roll. Senator Birdsall,
Yes.
Senator Ward,
Yes.
Senator Susie,
Yes.
Senator Perkins Coca,
Yes.
and the chair votes yes. And who wants to take that one out?
I'll be happy to take it out.
Senator Ward. I did see your hand go up there, Senator Perkins Coca.
Just trying to be a helpful member of the team, but I'm more than happy to defer to Senator Ward.
It was just a little slow. That's all right. So we already talked about primary.
Hey, we're only down to 3.
Well, I've got more than that.
Huh?
Maybe you're not counting the ones that we heard today.
7.
Oh, that's true because I didn't.
I've got 8.
All right. Campaigns and financing. We've got House Bill 263 and we've got 391. 391, I found if you haven't changed something since, I think when I looked it up, going through all the chapter law, I think I got back to 1997. And certainly what $25 would buy in 1997, $25 won't buy in 2021. And I understand that a lot of the people that are looking for fair and open elections are interested in keeping that number as low as they can. There becomes a limit sometime. And then you look at 263, I believe that is the one that would take the $7,000 that you can raise during a campaign cycle, 5,000, 1,000, 1,000, and say, we don't worry about this pre-primary. Pre-primary is lumped in with the primary, and we make it 3,500 and 3,500 and still retain the 7,000. again, that one I don't think has been updated in about 20 years also. I forget exactly what date I came up with when I went back to do the chapter law review to find that. But that one is kind of interesting to me. And the reason it's interesting is because most of the candidates that are first-time candidates don't think about raising money during, January to filing period. And so that when they actually file for candidacy, they're limited to the $2,000, which certainly does put them at a disadvantage to someone possibly who made that decision much earlier or is an existing candidate. I don't necessarily think the 7,000 is a good number. I'd like to see that go up along with the other fees. So I was thinking of trying to take the two bills, stick them in one bill. The one thing about the $100 limit that Deputy Secretary Scanlon talked about, if you're going to raise the 25 to 100, then the 100 that we have right now, which requires additional information about the donor, I believe should go up, by some percentage or some multiplier to that. Comments from you guys so that if I do decide to try and rewrite this into one bill, that I'll hopefully get something at the end that people can support.
So okay.
No, go ahead, Senator Ward.
Just want to have it clarified. Are you going with the increase it to 100?
Again, I think it should be increased.
Yeah.
If 100 is a good number, then it would seem to me that what I was earning back in 1997 pales in comparison to what I was earning in 2010 when I retired. Of course, I'm earning a little bit less now. But again, I think that the 25 number is quite low compared to what that dollar figure was, back when. So,
right.
What do you guys think is a reasonable number? Who thinks that 25 is a reasonable number? We've got one. Who thinks that 50 is a reasonable number?
Well, when we're doing, I'm trying to remember, when we're doing our campaign finance reports, is it anything over 25 or anything over 50 that we have to make sure that we have the name, the employee, or is it 100?
That's 100 cumulative.
That's the
The
100.
occupation information.
Okay.
So if in one contribution they give you $100 and 1 penny, then you need to include that additional information. But that is by election, so that if they gave you $100 in the primary and $100 in the general election, you would not be required to do that, per my reading of the statute. And I have been known to be wrong before.
I don't know. I need to think about this because I know there are some disadvantages to changing the, was it 263? Yeah, 263. I know there are some disadvantages to doing that, and I've got to try and look back and see why. As far as the increasing it to $100, transparency, 25 versus 100. I think the transparency issue gets when you're getting much higher numbers, because that's just the way it is, I think. Because I have a tendency to put when I do my campaign finance report, I put everything in there that I can, regardless of the dollar amount. So If it's a $10 check, I put in $10. So,
Right.
I do the same as well.
Yeah,
And,
I
I mean,
tend to do the same.
the issue with the cash now, I know that's I know when I've done my fundraisers and there's a basket there, people just throw, you don't know, you're off doing something, you're not sure who put what in. So that's covered under in the campaign finance report. So I'm not sure it needs any changing, but I'm willing to look at it.
Mr. Chairman, on 391, part of me kind of chuckled as the discussion was going on about how we need to index these things, we need to increase them. I believe I've been making that argument about the minimum wage for the last 10 years. And it was like, wait a minute, we're indexing both ways. But I do think from 25 to 100 is too big a jump. I would be open to perhaps another number. I don't know if 50 is the magic number. And I do have a bit of concern on 263 about the complete elimination of the voluntary spending. I know it's not often utilized, but I think conceptually, this bill takes all of that out, and I have a problem with eliminating all of it. But I certainly understand the need to revisit some of these things years later, and they need to be adjusted. So I'm more inclined to look at making some changes to 263 than I am to 391. If that part of 391 were folded in, I think we'd have to make some changes.
Okay. And
Agreeable to 50, so.
Yeah, I'm okay with 50, actually.
Open, but I would rather look at the two together and come back and kind of come up with one.
all right. And Senator Susie, I want you to know that I've seen an awful lot of signs here around Rochester that say $15 is what they're offering right now. So, even though we haven't taken action, the employers themselves in enticing those employees, $15 an hour.
That's
plus
right.
bonus.
We were driving up the coast yesterday through I should say northern Virginia. It's the northern eastern shore of Virginia, where you have Purdue and Tyson, and they had billboards saying that their minimum salary is $15 to $20 an hour working at those plants. I thought of you.
I might need to reconsider that vote.
If we're going to look at raising possibly to $50, the minimum, then that's a doubling of that, which if you took the $100 and you doubled that, you'd get to $200 before you would be required to put the additional information on a person. So I'm assuming that would go along with it, as an indication there. I have experienced people, especially business people, who are reluctant to have too much information because they believe that their customers might not be happy if they're supporting one particular candidate and the customer is of another. Just as an example of how deep some of these feelings are, I often make buttons when we have a table at the fair, and a woman was going by and I said, hey, here's a button that just says vote and had a big heart on it and a couple of things. And she says, no, I couldn't touch that button because it's been on those tables with the Trump buttons. And again, there are strong feelings on both the Republican side and the Democratic side about some of these things. So, it is a chilling effect, some of that information we make people provide. So just for what it's worth. All right. So 326. The sign-in sheet for opposed and supports, the numbers weren't that too far off. I don't know that it does a whole lot for me. So unless someone wants to speak more about that, I'm just going to put that aside at least until next week. Anyone else want to talk about that one?
You know, the prime sponsor wasn't there. As I said, I don't know if the intent is to trying to focus on local, town, or municipal election. I'm not sure, so.
Okay.
I'm trying to. Oh, I don't have a problem, and I apologize. We didn't get home till almost 8:30 last night, so I didn't get a chance to put files together. So I'm kind of going with the seat of my pants. But it's interesting that we didn't get any city or town clerks association to speak on this. So
Yeah, that was strange too.
yeah. So I'd like a little bit of time to talk to the Derry and the Hampstead and the Windham town clerk to get their thoughts. I'm not sure. They may have a problem not being able to charge. But you know, just running a report, especially if all the information is in ElectionNet, I'm not sure why this should be an issue.
Yeah, would you explain to me what the ElectionNet is about? This is the first time I've heard of it today.
ElectionNet is the computer database that the state keeps with the voter lists in it. That's
So I can go into SOS and just pick ElectionNet.
well, if you go into, probably speaks more to it. I think that in the RSAs, we generally refer to it as the statewide voter database.
Okay.
Or it's similar to that.
Okay.
If you go into the election manual, it may refer to it more as ElectionNet.
Mm-hmm.
But
this is what the town clerks and maybe the city clerks, when they get information back, when people are signing up, they enter this information into ElectionNet. So it's uploaded to the Secretary of State's office.
So then there is no need for anybody to request it from the town offices, right? If they can go directly in and pull it?
No, it's the only people that have access to it is the Secretary of State's office and the town clerks and city clerks.
Oh, okay.
And then the statewide candidates can subscribe. I think what Deputy Scanlon was trying to explain is they don't break it down. So like as an individual Senate candidate, you can't subscribe to ElectionNet and get that same information.
Okay.
Yeah.
all right. Moving along, House Bill 292. Personally, I like Senate Bill 54 a lot better.
Of course you do.
You know, pride of authorship. What can I say? You know? But again, I think that one we ought to wait till next week on.
Well, why don't we? This isn't a fiscal note, right? So maybe this is one we can hold on to and see what they do with 54. The number, I'm sorry, I just keep thinking of car 54. Where are you?
Where are you?
I'm giving my age away, but
well, I am trying to be sensitive. I think that on Senate Bill 54, that might have been a 3-2 vote out of the committee. So just.
But it was far better than this bill.
Okay. That's good. That's good. House Bill 555. I do think that we can make that list a lot better. And I'll see if Deputy Secretary Scanlon and myself can come up with a few words that would help to do that. And last on my list, let me find it.
243.
Yeah,
243.
243. And it's got to be here in one of these stacks. I included, after I sent you the copy of the amendment, which most people have liked, there was a gentleman that thought that we ought not have the budget committee be the ones that pick those subgroups, or have at least some other people along with them in the picking of those. I included that in some testimony, and that is up there. I think Tricia sent it to you, and it is posted. It's one of those things, if I try and do everything for everyone, this bill and the amendment will never get out. Okay. Most of the people, the finance people in the various communities that I've talked to, at least in Salem, Alton, and was talking to one of the budget committee members in Farmington, that what's described in the bill is pretty much what a lot of them already do. And that's pretty much what I tried to get this to go. If you haven't looked at an MS 737, because I think that except for Senator Ward, I think, Senator Birdsell, you're in a town too, right?
Mm-hmm.
So Senator Ward and Senator Birdsell, I think the rest of us are cities. So looking at an MS 737 isn't something that I do. I look at the budget in the city, which is, but the town meeting, they present either the 737 or the 637, the 636, the MS 27 for schools. I mean, there's a whole bunch of different numbers that they can submit, but that is the accounts listed on there is this uniform chart of accounts that a DRA produces, and saying that if you do things below that, you need to provide that information. As best I can, it was a good compromise to do that. Mm-hmm. So we haven't really had time to discuss the amendment before, and I want to open it up so that you can at least talk to, is this the right way the committee wants to go, or should we be scrapping this and doing something else? I need your thoughts, ladies.
Oh, I'm sorry. I just saw the amendment. So
I think to the extent it's what communities for the most part are already doing, it makes sense. I think it just provides a little more clarity in the statute. I don't know in really small communities if there's something else, but it seemed to me during the hearing that folks who testified felt that they already had a pretty standardized way of providing information. And in most cases, it was even beyond what voters requested. So
for an example, the MS 737 lists police, ambulance, fire. Okay. In a small community, and maybe I said this during the hearing, that if you've got a retired police officer from some other community that's moved to your community and now is serving as the part-time chief, and you have one deputy or so, maybe one light item for police is sufficient, and this bill wouldn't preclude that. But if you're in the town of Salem, Salem puts out a document that is 299 pages long for their budget. And it has sufficient detail. The one thing that I would like to see in Salem is not have to use a conversion table to get from their numbering system to the MS 737 or MS 27 in school district numbers. That would make it easier for someone, with the number of budgets that I've gone through over my career. I knew that they had to have a cross-reference, so I knew to ask for one. But the information that they're providing provides me all the detail that I could, if I want to know whether they're going in on police equipment and buying, protective vests or, fancy new collars or something else, I can certainly find that out. But so Senator Birdsall has just seen the amendment. Do we want to go forward today? Do we want to wait till next Monday?
I'm okay with going forward today. I'm here at the pleasure of the committee.
All right. So do we have a motion on the bill?
Ought to pass.
Motion about to pass. Do we have a second? Chair will second. And I will move amendment 1327S.
Second.
You have a second. Thank you. And we have discussion on the amendment.
Who seconded that? Sorry.
I-
Thank you. Senator Susie, I don't recognize the voice when my head is down.
My altered alter ego
Yeah.
is speaking.
Any further discussion on the amendment?
Mm.
Seeing none, I will call the roll. Senator Birdsall,
Yes.
Senator Ward,
Yes.
Senator Susie,
Yes.
Senator Perkins Cuoco.
Yes.
Okay, and now we have the motion is ought to pass as amended. Do we have any discussion? Seeing none, I'll call the roll. Senator Birdsall,
Yes.
Senator Ward,
Yes.
Senator Susie,
Yes.
Senator Perkins Cuoco,
Yes.
and the chair votes yes. Do I have a motion for consent?
So moved. Second.
I have a motion and second for consent. I'll call the roll. Senator Birdsall,
Yes.
Senator Ward,
Yes.
Senator Susie,
Yes.
Senator Perkins Cuoco.
Yes.
Chair votes yes. And unless somebody wants to, I guess I'll take that one out.
Okay.
You did all the heavy lifting, Mr. Chairman.
Exactly.
Okay. Did I go through everything, Trish? I know I did it out of order.
Yeah, no, we went through everything. And I will redo the list and the master sheet and everything for you guys later today so that you have it all for next week. And we're
Great.
doing 291 next week. Yeah, 291 is our last hearing.
All right.
Okay. I guess when you schedule that one, do you
Yeah.
think we can get it all done if we start at 10, ladies?
I'd like to think so.
It'll be nice.
So let's try that with the executive session to follow. And we'll try to give you an extra hour there before the meeting.
Okay.
And
I do
With
have a
that-
prime at 10:45 next week, just mentioning that.
Got a lot of bills out of the Senate, Senator.
I
Well,
did get some bills out of the Senate.
but let's move it back to 9:30 then.
Okay.
To give us that
Uh-oh.
extra
Good
half
compromise.
hour cushion, see if we can't get you off to your bill in the right time, Senator Perkins Coie.
Thanks, guys.
And with that, I'll,
Can I, Senator Susie, I know you talked about maybe getting together and talking about the primary.
Mhm.
So I have a 12:30 and then I have an appointment at 2:30. I mean, if you want to talk this afternoon, but what I can do, commit, is I'll talk to the Secretary of State's office,
Okay.
ask
Why
them
don't you
to
do that
find out
first?
some information from Vermont.
Okay. Why don't you do that first and then I'll.
Okay. All right.
in case you were wondering, that is lemonade. So
We finished with that bill already.
More lemonade in this committee.
Those were great floor remarks, Senator Susie. I just have.
I know, that was awesome.
Jessica and
That was
Marina worked hard on those. I just.
Yeah, they were great.
They were fun.
I
and
wish
do
we
we
could
have
take
a
credit.
motion to come out of executive session?
So moved.
Second,
We have motion and second. I will call the roll. Senator Birdsell,
Yes.
Senator Ward,
Yes.
Senator Susie,
Yes.
Senator Perkins Coie,
yes.
and the chair votes yes. Do I have a motion to adjourn?
So moved.
Second.
We have a motion second to adjourn. Call the roll. Senator Birdsell,
Yes.
Senator Ward,
Yes.
Senator Susie,
Yes.
Senator Perkins Coie,
Yes.
and the chair votes yes. Ladies, it's been a pleasure as always.